Call this meeting to order. And at this time, Frankie here. Call this meeting to order. At this time, I ask that Ms. Jordan, do you mind doing the invocation? Stand, please.
Our Heavenly Father, I want to thank you for the opportunity to bring all of us together today. Give us the wisdom and the knowledge to make good decisions for Cherokee Nation today and for the Cherokee Nation people. And let us be mindful that everything we do is for the people. Thank you. Amen.
Thank you, Ms. Jordan. Roll call.
Meredith Riley. Here. Gil Anglin.
Here.
Bill John Baker.
Here.
Jack Baker.
Here.
Harley Buzzard.
Here.
Julia Coates.
Here.
Bradley Cobb. Joe Crittenden. Jody Fishinghawk. Here. Janelle Fulbright. Here. Don Garvin. Chuck Hoskin Jr.
Here.
China Glory Jordan. Curtis Snell.
Here.
Chris Soap.
Honey.
David Thornton. Kara Cowan Watts.
Honey,
We have a quorum.
we have a quorum. Next order of business is approval of the October 25 and November 13. Are there any additions or corrections?
Second income tax.
All in favor? Are there any discussion? Mr. Garvin? All in favor signify by saying aye.
Aye.
All opposed, same sign. Mr. Garvin?
Madam Speaker, I'd like to amend the agenda to include two items. Number 5, under new business, bring the vote of Jennifer Barger for the Electors Compensation Committee. And number 6, bring to vote on John Ketcher for the other member of the elected officials of the Compensation Committee.
Second.
Make that in the form of a motion.
Moved and second. Any discussion on amending the agenda to include these two items? All in favor signify by saying aye. Aye. All opposed, same signs. We have item 5 and 6 under new business. Next order of business are reports. First is Marshal Service. No, Mr. Redcorn.
Thank you. How you doing? Thank you, Madam Chair, members of the council. For those who don't know me, I'm Jim Redcorn. I'm a captain. I'm the second in command of the Marshal Service. Sharon's in under the funeral today. I'm passing around a pack, and if I don't have enough, I apologize. I was trying to get him run off before I came over here, and I think I'm a few short. What I've done here is I've put our monthly report on the front. As far as the patrol goes, on the second page is the second section would be the community officers, what they've done in the community, and then after that I've done some yearly figures. The first section would be for narcotics. The second would be for community, and the last one would be for most of the investigations. I didn't get all the investigations. I apologize for that. But for the month of November, as far as patrol goes, we've had 20 alcohol-related events, 31 arrests, 20 assists for other agencies. And you can see the figures from there. We did a number of patrols that we've done per addition per county. I believe all the counties are in here this time. The community officers, Lieutenant Dreadful has been doing the majority of that. He does some, he has, what's his name? He has another officer that does presentations at schools. The narcotics officers, this is the estimated values of the number of drugs that they've had seized. First part just shows the street value of it. The meth labs shows the type of the labs and what the value that it could produce when it's operating. Then the street values for marijuana. And we estimate that for the fiscal year for 2006, 2007, the street value would be in the neighborhood of $605,000. The estimated number of years the suspects received was 198 years imprisonment. If you look on the next portion of it, it's broken down by county and which ones they were operating in. And the charges that were placed on them and the amounts that of narcotics that they had.
Anyone have any questions or comments in regard to Mr. Raycorn's report? Yes, thank you, Carol.
How's the, with the hunting season going on our trust lands, how's that going? I know,
What we're doing right now, is we are determining a baseline of the need. We're issuing citations for warnings for violations, and we're going to accumulate the number of incidents that we have and determine where the most need is, because as we've talked over before, there's a development of the game wardens, but it hasn't been funded yet, so we're just going out in these areas and determining what the problem areas are and what kind of problems we'll encounter once we begin to enforce these laws.
did I hear you say there's a development for a game warden type of position? Is that what you meant?
Yes, sir. There was a SBC proposal that we had made last year to fund some officers in that arena.
I think it was in the budget. I thought I saw it in the budget. I was just wondering where it is.
Yeah, I think it's awaiting a compact with the state before it's funded. So.
Okay, thank you.
Any other questions, comments? Yes, Mr. Snell?
On the game situation, if we're in Delaware County or all of Cherokee Nation, do we have any way of, how would I say, posting warnings or what we're enforcing? A lot of people say, well, we don't even know what they're doing, not they're doing.
Well, the enforcement is the law that was passed that only Cherokee citizens can hunt on restricted Indian land. As far as determining where all those places are, it's still, all those areas aren't posted. But that's why we're giving people heads up that, hey, this is Indian land. Some people have been hunting there for years and years as a non-Indian or non-citizen of the Cherokee Nation.
Well, maybe my question is, are there any way that we can get signs or notices or something?
Yeah, and everything was kind of done in a quick pace. That's why we're just issuing warnings and stuff until we can get everything rolling, and it'll probably be next year before we can really get a good establishment on what we need to do. But between now and then, we'll have the baseline that we established this year and the number.
We say between this year and say hunting season next year.
Right.
There's signs posted.
We're hoping that would be a duty of the resources to post those areas. Natural resources.
Thank you.
You're welcome.
Mr. Thornton and Mr.
Yes,
Jordan?
I think in that act that was passed, we have a section in there that pertained to non-citizens being able to purchase the hunting or fishing license.
Right.
And like you said, we've got people out there that's been hunting and fishing on their properties since they were kids.
Right.
Their fathers, and
Right.
look like their grandfathers. And we need to come up, I don't know who brings forward those laws and fix up, makes the rules. But we need to push that and get that done so those people can purchase those hunting and fishing licenses.
Right. And
And right now, we're saying they can do it, but you know, if we give them out a ticket for doing it, or for being on there, or making an arrest for them being on there, I don't know where we're at in developing those rules and regulations for that act. Someone needs to punch them a little bit and make somebody start bringing forth those rules procedures.
And right now, they aren't even issuing permits. I believe the process is if you're a Cherokee Nation citizen, you can go and get a permit. It doesn't cost you anything. The problem is the laws on haven't changed as far as Indian land goes. So they can actually hunt legally on Indian land, and before the act they could too. Hunt illegally on Indian land, but if they take that carcass onto the road or take it off Indian land, they're in violation of state law. And so that's why there's a conflict.
You're talking about Cherokee citizens.
Right.
I'm talking about non-citizens.
Right. And since there's not a permit system even for the Cherokee citizens, there's not a permit system for the
Well,
non.
the Cherokee citizens go by the rules and regulations of the state hunting and fishing laws, and they also can use their blue card for their permit. That's in the act.
Okay.
Okay, they show you their blue card, then they're legal.
Right. And
And the non-citizens don't have one.
right.
And we need to figure out a way to go ahead and get them so they can purchase a hunting and fishing license, you know.
So the way I understood that there was going to be a permit system set up, but that permit system, as far as
As far as I know, it's for
non-citizens,
non-citizens.
yeah, and I don't believe they're issuing any permits at all right now.
Yeah, they're not issuing any. We need a problem and get it fixed so, you know, they can give them out, because I've had a couple people call me, you know, that been hunting fish on their property since they were kids, and brought their kids up doing it, you know.
Another problem is if they're a non-Indian, the tribal court doesn't have any authority over them. So there would have to be something set up with
There's
the
no way
state
that you can give them
jurisdiction.
the ticket and make them come to
Right.
court.
Unless there's a court, there's a
But
complex
you
set
can
up.
list them as a violator. And if they and if they're listed as a violator, that counts against them on getting a permit to hunt or fish.
Mhm.
Is that right? That's the way
Well, right now, we're just determining a baseline, finding out who the people are that are actually going to be on this property, and see how much work needs to be done.
Well, this is
Because we're
what-
not really enforcing anything other than telling them, if you're a non-citizen, you can't hunt on the restricted land.
The one that called me said, you know, I'm going to sneak on there, you know.
Mhm.
And I guess he'd been caught and he left, you know, when y'all approached him.
Mhm.
He says, I'm going to have to sneak in the back way now. But he lives there next to the property.
There's a lot of things that need to be lined out before we start
Yeah.
enforcing full scale everything, especially the jurisdictional aspect of it, of can we actually prosecute these people in state court? Because if you have a violator that's non-Indian and the property's restricted and defended as a Cherokee Nation, it's actual federal violation.
But we
And you
also-
can't get a misdemeanor charge in federal court.
But we also, a spouse can go ahead and hunt on the property or fish on the property, I understand. The act.
By the act. I haven't read it in a while, but I do know there was a portion for permits in that.
Yeah, they are. Thank you.
You're welcome.
Jordan?
How are you handling the enforcement on individual restricted land, where the individuals have given permission, they're on the restricted land, it's in restricted status,
Mhm.
but they have given permission for their neighbors to hunt, or their non-member friends to hunt? How are you handling that?
We are, since we don't have any actual game wardens, we're making that part of our patrol aspect of it. So we're really just concentrating on the tribal property that's owned by the
So
tribe.
it's really the trust property
Right.
that you're talking about.
Right.
You said restricted,
Okay, well,
but
yes.
you mean trust, right?
Right. The places in Sequoia County and
The
in
common
Delaware
ownership
County.
land.
Right.
Okay, all right. I just wanted to make sure we wasn't infringing on the rights of our individual Cherokees to give permission.
No.
Okay. Now, the other thing I want to see if you could address is Could you all go out to Hilltop and alleviate the dog problem?
Yeah, when I first got that, they told me it was the circle up there, not Hilltop.
It's
It
the
was the other-
circle behind, off the highway.
Right, and that is in state, it's not, it's fee simple
Aren't
status.
you cross-deputized?
Yeah, we are cross-deputized, but if we go out there and enforce laws, we have to enforce state law. The only state law for animals running is not allowing to have a vicious dog
Well,
running,
there's some
so,
vicious dogs out there.
yeah. But,
I think Rottweilers, aren't those?
well, it has to be, it's not by breed, it's by dog. Has this dog been vicious before, and that's,
Could I get you to increase your patrols
We-
through the circle?
we patrol as much as we can.
Like a couple times a day
Well, we
for a
can,
while?
to look for dogs.
Well, just to make sure everything is safe out there. There is a problem.
I understand that. I understand there's a problem because I read the report. They called us and we sent an officer, not to that edition because they said it was another edition, and then I understand that Cherokee County went up there and found some dogs that had been left.
And I think they're handling the cruelty
Right.
situation, but I actually campaigned out there, and there's a lot of dogs out there, and there's a lot of little kids out there.
And I think what we need to probably do is look at setting up some kind of a system with a pound somewhere that would allow us to keep some dogs.
That was what I suggested, is that we think about a contract with the city pound to take in the strays that we might have to capture out there. And that we employ someone to go out and get those dogs, either through your department or through somebody's department. Because it's probably 95% Cherokee families there at Hilltop.
Right. And that's not the first time we've had to deal with dog problems. I mean, we've dealt with dog problems in the past for a while, and we always, and the majority of the time, it's going to be on fee simple property. And I don't even believe there's any tribal statute that says we can.
Well, and I
tribal
talked to
statute
Sharon
affects the
about
federal.
maybe we would do some, maybe get with Todd about a bill to assist in that endeavor. But that's going to take a while, and we need some relief. Those folks need some relief now, if you could assist them.
Okay.
Any other questions, comments? Is that all you had, Mr. Redpath?
No, I was going to cover a couple of things, and one of those were dealing with some of the hindrances that we have. We had gotten funded for a system that would allow us to, we don't have a database system. We got funded for one. The state said you can't have it because you're an Indian tribe. So we have a problem with storage of information and being able to retrieve information because we still do everything by hand, by paper. But and we want to increase our, and the system we were looking at would actually increase our ability to communicate with the outside agencies within the Cherokee Nation. So we're hoping to increase our ability to communicate better with these other agencies we're cross-deputized with. Another issue that we were talking about was, we're roughly the same size as Tahlequah PD, who covers 5 square miles. We cover about 7,000. When Pat Ragsdale delivered a report to the Senate, I believe last year, I'm trying to remember what the figures were, but I'll get close to them. They determined that for every 1,000 citizens, there should be 3.4 officers. With most of the tribes and outside agencies, it's more like 2.6. We looked at just the Cherokee citizens, the Cherokee population within the 14 counties, and in that aspect, with the Marshal Service, we're 0.3 per 1,000 Cherokee citizens within the 14 counties. So, one thing we try to do is to get out and go and do things, but it's really difficult for us because sometimes we have maybe 1 or 2, maybe 3 officers on at a time. So when I'm talking about trying to patrol places and patrol areas, we'll do the best we can, but I can't say we're going to commit to one certain area for a period of time. We have committed some guys up to the southern Delaware County, Oaks area, because I understand there was a need in that area. But we try to cover as best we can with the number of people, personnel there. But aside from that, I believe we stay pretty busy and try to take care of the needs of the Cherokee Nation.
Mr. Soap?
Yes, what's the Cherokee Nation Marshal Service's position on tasers?
On tasers?
Right. Been seeing it in the news.
C&E was talking about purchasing tasers for their security officers, and we were going to try to obtain some ourselves.
So you see them as a useful tool to...
They are a useful tool because if you look at the number of incidents where officers are injured or people are injured seriously because of altercations, and when the tasers were brought to the department, the number of incidents have gone down significantly as far as injuries to officers and injuries to other persons that are being arrested.
Do you guys have anybody that's trained to
We don't have
use
tasers. We don't have anybody trained to use tasers, but if we got them, we would. We have instructors in all levels of enforcement. We have firearms instructors. We have defensive tactics instructors for the batons and less lethal instructors. But as far as having an instructor for a taser, we don't.
Anything else, Mr. Soap?
No, thank you.
Any other questions, comments? Is that all your report, Mr. Redcorn?
Yes.
All right, thank you.
Thank you. Thank you, Madam Chair, members of the council.
Justice Department, is that you, Mr. Morton?
Good afternoon.
Good afternoon.
I'm standing in today. My name is Nathan Morton. I'm one of the Assistant Attorney Generals. And this is Angel Smith. She's also an Assistant Attorney General. She is doing the child support docket. And she's going to give you a brief presentation on how that's going and the progress, and then I'll come back and highlight you with some other stuff.
Good afternoon. We currently have approximately 3,100 cases. We believed with the transfer of 1,500 from Chickasaw, the agency that was handling our cases under compact. We have several caseworkers, more new caseworkers are coming in. We will also begin transfer from the state of Oklahoma identified cases right now for Cherokee children. Cherokee families are at approximately 5,000. Those will be phased in after the first of the year. We are fast and furious in 6 counties right now. 5 counties, and then also tribal. And eventually we will begin transferring more of the state cases from the dockets into our tribal court. We're continually taking in new requests, new paternity actions, child support. We are adamantly working. We have 3 people assisting in legals, and we're doing very good. There have been very few complications. I'm very pleased with the work that we've had with the child support office itself. And we have a law firm we're currently working with that is under contract. We will eventually hire on some additional AGs who will be assisting also with the cases. So as of right now, we're kind of, it's myself and then a few lawyers from the other firm. Any questions?
Any questions from Ms. Smith?
Thank you.
Did you say you had 1,500 cases from the Chickasaw and 5,000 from the state?
We were supposed to have 1,500. We ended up with approximately 3,000, plus with new intakes, so they're at 3,100 at the last count. Mm-hmm. And yes, there are 5,000 identified cases coming from the state after the first of the year. So we are moving quickly.
You're busy.
Yes, ma'am.
Thank you.
Thank you.
See, also I attended the State Bar meeting this year, and I think we're making progress as to have our office become associate members of the District Attorney's Council. There was a child abuse investigation earlier this month. It was a seminar, and Sarah Hill with the Attorney General's office took the lead on that from our department, and from what I hear, it went well. I was unable to attend it, but it was well attended. Also, there is a pending lawsuit involving water rights within our jurisdiction. Gave a copy to Mr. Hembry, I think Ms. Hammonds did, and reviewing that right now. I believe the answer date's coming up next week. Are there any other questions?
Mr. Buzzard?
Who filed, who's it with on the water rights?
Grand River Dam. And I can have copies forwarded.
I'd like to have a copy.
Mr. Soap?
I was just going to ask the same thing.
Any other questions? Mr. Anglin?
Does that include all of the GRDA properties downstream?
It specifically listed several bodies of water. I don't know specifically offhand, but I will make sure there's an electronic copy made, and I will forward it, and then it can be sent out. I have a paper copy, but I made the mistake of writing on it first, so I'll get you a clean electronic copy.
Thank you. That's all.
Thank you.
Questions? I have a question, Nathan. Does the immigration, are we impacted as a sovereign at all by immigration laws? The reason I ask is they're having a seminar, I think it is, next week in Mays County on immigration law. What I was thinking about is if our contractors or subcontractors hire non-Indians that are illegal immigrants, could we be impacted at all by the safe harbor rule? Do you need anything for protection of our contractors and subcontractors, etc.?
I do not know, but I'll find out. What day is your seminar?
I think it's next Tuesday or Wednesday. I'll email you and let you know.
Okay. I'll work on that.
Okay?
Thank you.
Election Commission, being no one here, we'll move on to Tax Commission. Ms. Swepston? Oh, hello.
Yes. Good afternoon. For those of you that don't know me, my name is Greg Simmons. I'm a tax specialist at the Cherokee Nation. Sharon's at a funeral today. She'll be back a little later. I'm just going to give you a couple of highlights. She submitted a written report. Motor vehicle revenues are up about 18% from last year, and our revenue and taxation, which includes our sales tax, alcohol, tobacco, that's up about 5% from last year. And if you have any questions, I'd be happy to try to answer those.
Any questions of Mr. Simmons or on the report? That was short and sweet. Thank you.
You're welcome.
Ms. Hanby, self-governance.
Good afternoon. Although I am short and sweet, my report probably won't be. We've had a very busy couple of months in self-governance. One of the first things that I want to be sure and go over with you, and I've provided you with a handout that talks about Title IV amendments. It's just a one-page briefing on Title IV amendments. And what that is, within the Self-Governance Act, there's Title IV, which applies to the Department of Interior. There's Title V, which applies to IHS. Title V came about a few years after Title IV, and tribes had learned through experience some better ways of doing business and some things that we've learned from experience that we put in Title V, which currently are not in Title IV. And so the tribes have been working for a number of years to propose some amendments to Title IV to bring it up to the same standards that are in Title V. So Congressman Boren last month introduced a bill to Congress for Title IV amendments, and we're very thankful and pleased that he did that on our behalf. We attended some meetings. Deputy Chief Joe Grayson and Paula Ragsdale from the Washington office, we attended some meetings on those Title IV amendments with Boren's staff and some other tribal leaders and a room full of attorneys. And there's going to be a meeting next week to continue discussions. There's about 14 items that are still in disagreement between the tribes and the Department of Interior. The major issue with the Department of Interior surrounds non-BIA agencies like the BLM and other agencies within the Department of Interior that tribes have a cultural or historic interest in doing business with those folks or compacting some of those services. That's probably the major item with the Department of Interior that's still an outstanding disagreement. We also attended, in regards to Title IV amendments, they also held a hearing on those amendments and the disagreements between the department and the tribes, and we attended that hearing, as well as another hearing on the Indian Health Care Improvement Act. We also attended the Department of Interior Advisory Committee, and for those of you who may not know what that committee is, it consists of tribal leaders from the various regions across the United States. We sit on a committee and provide advice, and we discuss various topics that are of concern on a national level with the Assistant Secretary, who currently is Carl Artman. I've also been participating very heavily in the National Contract Support Cost Work Group, which the contract support cost policy was passed last year, and we're working as a joint federal and tribal work group to implement that policy across the nation. And we're going to be holding some trainings in Oklahoma for the Oklahoma tribes. Rhonda Butcher with the Citizen Potawatomis she's working with me for the Oklahoma tribes to present that training next month. I also worked with Harry Rainbolt in the D.C. office on the shortfall report, which the Department of Interior has, by law, been required to submit to Congress. However, they've not done that. And so we are developing a shortfall report, which in essence outlines the amount of dollars nationwide that tribes are not being paid on contract support, how much we're underfunded. And it's very similar to what we're already doing with IHS. But anyway, I sat down with him in his office and worked on an Excel spreadsheet to try to get that, to assist them in helping get that report filed to Congress. We also attended the National 102-477 Conference, which is, we have the child care through the Department of Health and Human Services, and also our training programs through the Department of Labor that we brought under self-governance. We attended that national conference, and that was a very good conference. We also sponsored someone to attend from Financial Resources, so that they could sit in to the financial side of 477. And I have to say that was probably one of the best, if not the best, trainings that I have seen someone put on financial training. And I was very pleased to sponsor an individual to sit in on that. We also attended the Indian Land Consolidation Work Group, and we've also assisted with compliance and evaluation within government resources on several internal control reviews and assisting them with the NAHASDA review. We are still proceeding with Department of Interior negotiations. We held a meeting just this week. We didn't get very far, but those negotiations are ongoing. We've also been working on getting us funding for the Muskogee joint venture. So far we've only received 2 months worth of funding in 2007 for Muskogee facility. And as you know, we are on a continuing resolution currently. We'll have a second CR, and we're anticipating a third continuing resolution. And we have received verbal commitment from IHS that they will request from Congress for us to go ahead and receive our funding for Muskogee. We have received that commitment verbally. But we are also working with Paula Ragsdale in the Washington office to work the legislative route as well and see if we can't get some funding for that facility. Next month we will also be hosting some on-site training for OMBA 87, which is the cost principles for federal programs, and that on-site training is to cover fraud, waste, and abuse, and we'll be hosting that from our department. And I think that's all of my report, unless you have any questions.
Yes, Mr. Hodgson?
Thank you, Madam Speaker. Ms. Handy, with respect to the ISDEA and the Indian Healthcare Improvement Act and your visits in D.C., do you get the sense that the Congressional Black Caucus is attempting to attach any legislation, any amendments to those pieces of legislation that might somehow have the same effect as the housing amendments we read so much about in the past few months?
Well, of course, Paula Ragsdale would be far more knowledgeable about that than I would. I don't think so at this time, but I know that they're going to try to attach to anything they can. But she would be more knowledgeable about that in particular than I would.
Mr. Badger?
Yeah, Vicki, on number 4, on contract support, is there ever going to be a chance of us getting any contract support for transportation? It's funded through Federal Highway Administration, and we haven't got any contract support for transportation. It's only the 6% that they get, and that goes to the area office.
Right. I can say it's not part of the discussion. It's not covered in the policy, and I think the Department of Interior looks at that as a Department of Transportation issue.
And that's the way it has been looked at.
And
I think what we were trying to do is get part of the 6% that goes to the area offices, and I don't know if we've been successful in doing that or not. Yeah, for administration.
no.
The other question I got is on proceeding with DOI negotiation. Just a brief overview of what are we negotiating with them?
What are we negotiating?
I know there's a bunch, but
We have a multi-year funding agreement which will cover, you can only cover 3 years, so we're doing 08 through 010. 2010. So we have a multi-year funding agreement. We have the roads addendum.
So that's on there.
The roads MOU, yes. And also with the Office of Special Trustee, we have 2 MOUs that, one for appraisals and one for what used to be referred to as IIM is now referred to as BPP. But we have those that are on the table.
Okay.
Probably
That's what I was wondering about the multi-revenue contract.
The roads agreement is, I think it's very close to the model agreement, and there's just a couple of items that we differ on that we need to work through. The major items are within the multi-year funding agreement, particularly security issues.
Okay, thank you.
Any other questions for Ms. Hanby? Thank you for the report. Anyone here from the Gaming Commission? Anyone here on codification? Mr. Hembry?
Yes, after long consternation on the issue, I began myself starting the codification process. Actually took advantage of the long holiday weekend to get that. I'm going to forward what I've done, which is probably a third of the titles, to Ms. Hammonds, so the Attorney General can come along with me in this process. Our software OCR, what is it? OCR. OCR software will be in next week, which will help us scan in all our past acts, and so we can make any changes on them, without having to retype a lot of information. So that's going to be helpful. So very positive. Work is beginning and continuing, and we're going to get this done.
By December 31st?
I no longer make any promises. It will. By end of December is not an unrealistic
request.
Goal. Yeah. Okay. Thank you.
Thank you, Todd. GEG, is anyone here to talk about GEG and the status of that? Mr. Morgan?
The investigation is still ongoing. A related matter, the civil case in Tulsa County with Mr. Majewski, has a motions hearing set for next Wednesday in Tulsa County.
Any questions regarding GEG? It's not. Thank you.
Thank you.
Moving on down to old business is a legislative act relating to Native American arts and crafts. We did hand out a paper from Bill Glass and his son, Ms. Helm Watts.
Yes, so this is not, I'm not for sure exactly how to handle this because the act is the truth in advertising. So the title has changed, so we've got 1 under old business and we've got 3 under new business, but the truth in advertising was pushed back to rules, which is the same act but modified, and that the title changed and everything, so we saw this at full council. So what's the proper?
This would be my recommendation, is item 1, for tracking purposes, that we would need to table that act indefinitely. That would have a coda or an end to this act.
Well, I'll just withdraw it.
Or withdraw it, and then consider your new act under new business.
Under 3. So I'll just withdraw this one.
That's it. I just want to make a motion.
So we're withdrawing the legislative act relating to Native American arts and crafts. Moving on down to new business. Ms. Coates, and do you want to present the resolution amending the National Historic Preservation Act?
Correct. This is a resolution that I brought in the Education Committee a couple of weeks ago. There were some last-minute objections to a couple of the words from Janine Hale and Environmental Protection Commission. So with Melanie Knight's assistance, we have reworded this slightly. Again, the background on this is that the Elam Band of Pomo Indians in Clear Lake, California, has requested of tribes across the country resolutions in support. They've had an issue going back 50, 60 years of a relocation of people out of their village on their reservation to so that mercury mining could take place. They reoccupied the village after that mining had occurred, but then discovered that almost 50 years later that there was significant mercury contamination in the area. It became an EPA Superfund cleanup site, and in the process of EPA Superfund coming in to clean up and excavate the region, a tremendous amount of the cultural patrimony of the Elam Band of Pomo Indians was destroyed. Both skeletal remains, historical artifacts, cultural artifacts were destroyed. The Elam Band was repeatedly told that Superfund was exempt from National Historic Preservation Act requirements. And so what they are requesting at this time of other tribes is a resolutions of support in their efforts to close the loopholes in the National Preservation Act, or in the National Historic Preservation Act that does not incorporate CERCLA, the Superfund regs. So this is the resolution that I'm asking for in support of the Elam Band of Pomo Indians.
I'll second that. Moved and second. Any discussion? Any discussion? All in favor of this resolution signify by saying aye. Aye. All opposed, same sign. Motion carries. Second item is an act allowing remote attendance of members of the Tribal Council for meetings of the council and committees, and that's also Ms. Coates.
Yes. This is an act which would allow for the at-large Tribal Council members and council members who are absent because they are on Cherokee Nation business to attend council and committee meetings by remote teleconferencing. And I would put this in the form of a motion.
Second.
Moved and second. Any discussion? Mr. Baker.
Yes. I would prefer that it only relate to committee meetings at this time until it's developed. And I would like to see the official tribal council meeting be taken out of the act at this time.
You don't think that is an amendment to it?
Yes.
I would accept that.
Yes, excellent.
Any further discussion? Todd, I sent you a question in regard to this legislation. Isn't there a potential violation of the Constitution here based on the Grayson case and the Holder case?
There's can it be challenged? Yes. Are there good arguments for the act? I would say yes. I believe it is within the purview of the Tribal Council to determine what in attendance means. That is not to say that a counselor or any citizen of the Cherokee Nation that could demonstrate standing could not bring a challenge to this act. Now, and that would be up to the obviously eventually the Supreme Court to decide. But it is my opinion that the act as written is constitutional. One thing that also in your memorandum, and is something that the committee may discuss, is the issue of chairmanship at a committee. If a person is going to be absent because of official Cherokee Nation business or an at-large counselor, and it is their duty to chair a committee like Ms. Coates, that if she's going to be absent, she might assign that duty to her co-chair or some other person, because it would be difficult to chair a meeting via video conference. And that's one thing, that this is interactive video conferencing, so that you can see the person and the person can see you, and there is a full engaging of debate on the issues. And also an important part of the act is that, and what I think makes it constitutional in my opinion, is that there must be a physical quorum present in order to carry on the meeting. You can't have 9 video screens up here. You will, in order to carry on a meeting, you will have to have a physical quorum present.
Mr. Soap and then Ms. Jordan, and who else had their hand up?
Is Tony, are you aware of any other government that this particular remote meeting attendance takes place
The
in the world?
Well, the state of Oregon is contemplating it. In my research on it, and this is something that as technology advances, many governments are considering this type of attendance. Oregon is contemplating. It's not the law yet. Virtually all major corporations allow this.
Governments.
Right, but governments, we would be on the forefront of it.
Mr. Soap?
Yes, thank you.
Ms. Jordan?
Todd actually covered what I was going to ask about, was how do you handle the chair issue, because it's going to be somewhat a learning process for a while to figure out how to interact by the video. So I would be kind of concerned if that's going to be I know we have co-chairs, and I wondered if you might want to put something in your act here that would cover chairmanships during absences.
I would recommend that in difference with the author, but I would recommend a sentence.
Yes, if a chair is not going to be physically present, that it be delegated to the co-chair
The co-chair.
to chair that particular meeting.
And
I
if
would
the-
be perfectly comfortable.
I would put that in the form of a friendly amendment then.
I would accept it.
Second accepts.
We have two amendments on the floor.
I'm sorry.
Well, both were friendly amendments, so they were accepted automatically.
Okay. Any other questions, comments? Oh, yeah, I'm sorry. Dr. Cobb and then Mr. Hoskin.
Councilor Jordan covered mine. That's what I was going to suggest. I just want to make sure, since I'm not an attorney persuasion, I want to make sure this does specifically state that you have to physically have a quorum present at the meetings.
Yes, it did. In substantive provision, section A, at-large members or Cherokee Nation Tribal Council of the Cherokee Nation Tribal Council may attend tribal council meetings and or special council meetings or committee meetings. We're going to strike council meetings through the aid of a device which provides for two-way transmission, both visually and audio communication, provided that there is otherwise a quorum physically present at the location of the meeting, etc.
You okay with that, Dr. Cobb? Mr. Hoskin, and then Mr. Baker.
Thank you, Madam Speaker. I don't know that I'm familiar with both of the cases that you mentioned a while ago, but wasn't it the case with both of those cases you decided that it was a quorum issue, proxy voting and a quorum issue?
Holder was a quorum issue. Grayson was a proxy issue. And that was when the tribal council had in their rules of procedure that you could give your proxy to an individual. The court ruled that no, you must be in attendance to actually vote. Now, they did not define what in attendance is. This act sets what in attendance is. And, is that up to judicial interpretation? It may be if challenged. But I believe it is within the council's purview to define what in attendance means.
So no one would have the quorum is sort of taken off the table because of this, because of the substantive provisions, but there's still a possible challenge on the basis of that's not attendance.
Correct.
Okay. And then secondly, just an observation, Madam Speaker, I actually use this technology on a weekly basis, if not more. It could be that I don't have the state-of-the-art stuff that we might get, but it is frustrating at times. You sort of like on a cell phone, you talk back and forth, and sometimes there's some cutoff. I think the stuff gets better as time goes by, but there's going to be some limitations, but probably something we can live with.
Mr. Baker?
Yeah, and when you take the council meeting out under, you take the special council meeting as well?
Yes. I mean, that's my assumption on the minutes is that this would only apply to committee meetings, that any meetings of the council, full council or special council meetings this act wouldn't apply to. This is
Why
only
are
apply
we
to-
striking those meetings right now?
Pardon me?
Yeah.
Well, I think that we need to work out the technology and see how it works before we go into the full council, because right now I think everyone should be present for the full council meetings. But if we get it up and running and it's working really well for committee meetings, then I would have no problem with changing it to the full council.
Well, I could just see how maybe we might do special by virtue of it's a single item and on a shorter notice and not necessarily planned and all, but I could see waiting until we get it down pat here first.
Ms. Jordan?
Under, Todd, under section 4D, it defines official Cherokee Nation business. Well, I noticed a couple little typos there, but,
Don't know how those question marks got there. They should.
okay, you've got means work or duties performed directly related to and for the benefit of or on behalf of Cherokee Nation. So they could either be on council business, they could be designated through the executive branch to be on a trip somewhere.
Yes, and I didn't mean to.
In other words, we're not going to have a question about what is official Cherokee Nation business at any time, are we? Should we tweak that a little bit to be more?
Well, I purposely left that definition broad, and this is the reason, is that often, I didn't want to limit it to tribal council business, because the chief or other entities, maybe even Cherokee Nation businesses, CNE, etc., may require you to be absent. And I guess the simple rule that I think we should go by, if the Cherokee Nation is paying for your trip, you're on official Cherokee Nation business. And whether it's by offices of the chief's office or Cherokee Nation Tribal Council or any of its entities, that it should be allowed. But that's why I left that definition purposely broad.
And I'm assuming the technology we're going to use is through our new laptops.
I'm not the tech person. Whatever needs to be, implemented to implement this, I would suggest.
Todd, can you clarify that for her?
The laptops would be part of that technology. And I just wanted to point out a couple of things. The greatest variable is if we have half the council out, we wouldn't have a quorum. But if we had 4 or 5 out, or 3 or 4, and still had a quorum available, the challenge might be is that Julia may be a CNB board session in Omaha, Nebraska, in a hotel room, and they don't have internet service, and that's going to present a limitation to Julia. Tina may be in Washington D.C. and is in an area that has stable internet connection. That's going to be the hardest piece for us to work through. We can test the cell phone technology with the wireless cards that you have for the remote connection. The only challenge to that is the throughput may not be high enough to sustain a stable connection. A lot of it's going to depend on where the location is. So it's going to be based on location and what the internet availability is going to be. And sometimes it may work great, and you may be in an area where it may not work very well. So there are going to be some challenges, like Mr. Hoskins pointed out. There is somewhat of a time delay or a lag. It seems like an eternity sometimes, but it's actually just a second or 2 delay when you ask a question and it gets translated and pushed through and then they respond. It seems like it took several seconds and they didn't hear you, but they're actually hearing. It's just a several second delay. So there are going to be some challenges based on location. It's definitely something we can move towards.
Charles, did you have a question?
Probably a question for Mr. Embry. With respect to 4D, that doesn't put the council in a position of having to someone object and say that's not official Cherokee business. If the councilor says they're on official Cherokee business, the only challenge of that would be a legal challenge, not a challenge within the body. Is that correct, or do we know?
Well, I would hope that you would satisfy that question beforehand. Of whether if someone's going to object. I would say that any counselor has a right to take advantage of this, and if someone objects, that they would need to bring a court challenge to it. But like I said, it's pretty simple. In my opinion, it's broad enough that if the Cherokee Nation's paying for it, you know, more than likely you're on an official Cherokee Nation business.
Thank you.
Baker?
Would we want to broaden it for hospital confinement, health reasons? I mean, I remember we had to bring Tina's dad in on a stretcher or at least a wheelchair on a couple of occasions when he was gravely ill to come in and fulfill his duties. And I mean, the technology's there, and all, why would not we allow maybe a convalescent council member to participate and represent his people?
That's up to the will of the body.
I would offer it as an amendment.
My question, is there a way to do that? Because that's an area where I would see us opening up for abuses. I mean, what you're talking about are really legitimate things, but is there language that we could employ that would really look at that on a case-by-case basis? Because if there is a situation of long-term, you know, really convalescent situation, then it would be a very legitimate purpose. But somebody's got the flu this week, you know, may not be, and so would there be a way to accommodate that, a case-by-case sort of?
And this is thinking on the fly, but what of a kind of caveat at the end of that sentence, or any other or any other situations in which the majority of the council approves? You know, if you know, that way we don't have to define what illness is, but if the majority of the body says, yeah, this is an instance that, you know, we should allow remote, it's up to you to allow remote.
Do you accept that?
Yeah, I think so.
Okay. I will word that, and obviously get another crack at this at full council, but or any other.
Would you accept something more than just a simple majority? Because I see where that might.
Yeah, that's a good point. A 2/3.
2/3 majority.
If 2/3 of you all agree that it's that the person should be allowed, that's pretty legitimate.
Well, the reason I bring that up, since you bring my father up, I'm assuming, you know, if you have terminal cancer and you still want to represent your people, that we would have no trouble with mustering 2/3 of the majority to do that. But a simple majority seems a little, it should be, I think, a little more. I would just ask that you consider that part as a...
I wouldn't mind bringing the amendment to
2/3.
2/3.
So, Todd, your opinion is, although Grayson ruled that a tribal council person cannot be in attendance by video to vote or to constitute a quorum. That was the holding in Grayson. So I assume they can appear by video in order to constitute a quorum. But to me, I can't get it clear in my head how they can vote from a remote distance.
Well,
and still be constitutional.
Well,
based on that holding.
This is well. Grayson says that they need to be in attendance to vote. Okay, and there was a paper proxy situation in which Councilor A gives his proxy to Councilor B to vote in any way that Councilor B sees fit. This is different, and this is why I think it's different, is that it allows the councilor to engage in the debate, listen to the debate, and participate in every aspect of the meeting. I believe it is within the purview of the tribal council to define what in attendance means, and this is a legislative act that so defines it. Now, can it be challenged? Undoubtedly it can be challenged. But I believe that this act will withstand a constitutional challenge.
Mr. Hoskins?
Yeah, and I think you were clear, but let me make sure I'm clear. Grayson did not deal with the video.
No.
It dealt with a proxy.
Pure proxy. Because the difference between this and Grayson, in my opinion, is that it had that the proxy giving counselor in no way could have engaged in the debate or the or any process in the meeting. It literally gave up my constituents' rights to another counselor to vote as is. All right. This is, in my opinion, the key difference between this and Grayson is that there is that engagement. There is the legislative process is preserved because they are taking part in the debate, the amendments, and they know what's going on. And there's a give and take, and there can, they would be able to make a knowledgeable vote on any action.
Very good. Thank you.
Ms. Coates.
I would ask for passage of this act because I feel confident that, as Todd has explained it, that the legal challenges, any that may come up, can be withstood. We've got a different situation at this time than we did from, in the period of the Grayson lawsuit, in which we have 2 new at-large council representatives who represent over 60% of the citizenry of this nation. And Jack and I are both in a situation where I plan to bend over backwards to be here, for the regular committee meetings and council meeting, even though 6 months out of the year it's going to require me to travel quite a long distance. Jack has to travel some distance as well to be here, but not a whole lot further than those from District 8 have to travel, on the other hand, or 9. And so it will constitute a real hardship, I think, for future at-large counselors to not be able to participate in this way. And we want to think about that, that it's not simply Jack and myself, but this is for all of those who will come in the years ahead, and their ability to represent a really, really significant proportion of our citizenry at this time. So I would just really ask for passage of this act to enable that.
Mr. Todd, did you have a comment?
Madam Chairman, and also I forgot to mention that in particular with the friendly amendments that have taken place here today, this deals only with the committee process and not at full council, which is the constitutional language applies only to. The Constitution clearly states that the council has every right to establish its own rules of procedures and decorum, and I believe that would make this even further constitutional.
Any other questions, comments?
Call the question.
Question's been called. All in, let's see, this is roll call.
By acclamation.
Acclamation. All in favor signify by saying aye.
Aye.
All opposed, same sign. Aye. There's going to be one. Okay, motion carries. Yeah. Okay, next item is item 3, legislative act requiring truth in advertising for native art. Ms. Helen Watts.
Thank you. At this time, I would like to make a motion to approve as provided with one amendment taken from Mr. Glass's letter that we should and could include, not that it was meant to be excluded, but to include contemporary art or techniques in the definition of Indian art. I'd like to just make a motion to approve it with that one amendment.
Have a second?
Second.
Any discussion? Yes, Ms. Gordon? And then Mr. Soap.
I just want to make sure under section 5F, where it says this act may be enforced by civil action of any Cherokee citizen for injunctive relief and or damages. Who are they going to sue? If they want to sue?
It would probably be the entity that would be in violation, because that would be the only one is if somebody purchased art that was not appropriate.
Would that not be Cherokee Nation?
The chief wrote that part, so
I mean, are
I don't
we
know,
not waiving our sovereign immunity?
I apologize, I'm relying on lawyers to do this, so.
Well, what I would recommend is that the entity that would be sued would be the Cherokee Nation. And this is what I would call an implicit waiver of sovereign immunity. We all know that implicit sovereign immunities do not work. It has to be clearly expressed. So we might add in Section F that for the purposes of this Act, the Cherokee Nation waives its sovereign immunity for injunctive relief. Not damages, but waives its sovereign immunity as to injunctive relief. That's I would make that recommendation.
Would that be acceptable? So the amendment would be, so Section F would read, it would delete and/or damages, and then it would be on the end.
Meanwhile, the Cherokee Nation hereby waives, expressly waives its sovereign immunity for suit under this Act for the purposes of injunctive relief.
Ms. Jordan?
Well, I hope we're not going to easily waive our sovereign immunity for anything. Folks, let's think about what we're considering doing here. That's a pretty important step.
Pardon me, I did not hear the question.
Well, it's a comment more than it's a question. Let's think very carefully about waiving sovereign immunity on such, even for injunctive relief. I just think everybody needs to understand that's an awful big step.
May I pose a question?
Okay.
So do you have, as a lawyer sitting on the council, do you have some way that these folks could have some means of enforcement on this act?
Well, I'm not sure that we even need F. I trust our powers to be to do the right thing in this particular instance. I would oppose anything that, of course, I'm just one of 17. I understand that. But sovereign immunity, when waiving it, is very important. I think we need to think about this very carefully. I don't know that we need F.
I will accept that as a friendly amendment, just to remove F.
To do what?
Just to remove F. And my second accepts
I
too.
second. I accept that.
Mr. Soap?
Yes, I was just would like to make a request in the form of a motion if necessary that be time allocated as determined by the chair for public comment. I know in the past we've said that there's been plenty of time to comment on this issue, both via emails and letters and all that kind of stuff, but I would just like to request that there be time made in this committee for public comment.
You mean today?
Yes, before we do any
Before we
further
vote?
votes. Yes.
Okay. Let me get Mr. Hoskin and first here.
Thank you, Madam Speaker. Well, Mr. Hembry, if F is struck, then by what mechanism do citizens ensure that the act is enforced? I mean, for example, if someone wanted to sue because they didn't agree with the labeling, or the labeling wasn't actually done, for example, there's other provisions, they have to come to the, how can they access the courts to enforce this?
Well, one way would be to contact the Attorney General's office and make their allegation that there is an official, either elected or appointed, who is willfully neglecting his duties of office, his or her duties of office. Also, there would be ways to bring forth action via the council if let's say C&E is violating the terms of this act. That means the board of directors is not following the laws of the Cherokee Nation, and that is a basis for removal of directors of corporations. That is one instance in which enforcement can take place.
Do any of our other regulatory acts contain limited waivers of sovereign immunity, to your knowledge? And I don't have one in mind other than maybe the Environmental Protection Act.
Taro? Yeah, Taro does. Cherokee Nation has opened up in unlimited basis under Taro, I believe. Yeah.
Thank you.
Mr. Baker?
Yeah, under Section 5, under B, Cherokee Nation shall not host, sponsor, fund, or otherwise devote or contribute any resource to art exhibits allowing the exhibition of works by artists who falsely claim, imply, suggest that they are ended. I've had several comments that it could possibly impact the Heritage Center, some of the nonprofits that we donate to, that unbeknownst to us, might do a Willard Stone or might do a display or allow students that self-proclaim to be Native American to have artworks in their shows and stuff. And I guess I'd ask that we drop that one as a friendly amendment.
Can I comment? I think it goes to this.
Okay.
I want to be clear on this because I think it goes to your question. Because I know Willard Stone and some other important artists fall into this and have been brought up in discussions. The sentence specifically says who falsely claim, imply, or suggest that they are Indian. I just want to make sure the language, because some of the things that have been brought up is people say, well, the Cherokee Nation can't sponsor this, or we can't be associated with that. The way I'm reading this, it doesn't say we can't. It says we can be a part of those, but this specifically says if they falsely claim. Am I reading that correctly? Okay.
Truth in advertising.
Right, okay, exactly. Because this isn't saying that we can't, for lack of a better, help me if this isn't a good explanation, a good example, but there's a Willard Stone exhibit. Well, we can be a part of that as long as the Willard Stone family / trust or whatever doesn't falsely claim that he is a Cherokee citizen or implies that. That's the way I'm reading that. If they come up and say, well, he's not a citizen, but he's an important part of the artistic history. So that's the way I'm reading that. So that when you were making that comment, that's the way I'm reading that sentence. Thank you.
Jack, help me.
Actually, I didn't agree with Dr. Cobb that if they claim to be Indian, as long as the claim is not there that they're a member, and we have Indian defined top of the page as a member of a federally recognized Indian entity under the Federally Recognized Indian Act of 1994. So as long as they're not claiming to be a registered tribal member, then it should be okay.
Well, were they not telling me something about the art show that there are non-federally recognized Indians that participate in that?
There are in the Trail of Tears Art Show at the Heritage Center, but it doesn't preclude it. It's just it precludes our saying that they are members.
So
they are federally recognized.
So as long as you all out there label it,
right,
then it's not going to preclude us from helping sponsor that art show.
Right, it is not.
Well, a lot of the misinformation or the confusion and stuff with the artists were that somebody's going to slip in and do something, and then you all are no longer going to sponsor these art shows that we depend on.
No, it's as long as it's the labeling. I think Section 5, Item E takes care of that. Is that it's to be labeled as Indian art, and they can't claim that it is otherwise. So as long as we're not claiming that it's by a...
So how do you do little people out there? You don't...
Well, see, we haven't had to do this because it's hasn't been that bad. And for the Trail of Tears Art Show, then anyone would participate in that, whether they claim to be Indian or not. Because we have participants that do not even claim to be Indian as part of that.
Is that a no?
Yeah, I'm not accepting that.
I'm just curious.
You're welcome to make a motion.
It's sort of the heart of the...
That all, John?
That's it.
Ms. Coates?
I just wanted to basically affirm what Jack has just said, actually, Councilman Baker, and it's one of the things that is most difficult for people to understand in the history courses that I teach as well, and it's been most of the misunderstanding in the emails and things that I've received from people also, is that we're making an ethnological and political distinction here, and under federal law it is the political distinction as members of citizens of federally recognized tribes that we're going by. Now, we're not even addressing the ethnological description of heritage, that is a totally different claim. And as I'm perceiving this, the labeling will be affirmative. We're not going to label things that this is not an Indian, right? We are going to label things that this is an Indian, right? And by the legal definition that this is someone who is a citizen of a federally recognized tribe, right? And that there's nothing here that excludes or precludes us from being able to also exhibit and even sell, I think, the works of people who are not politically defined as Indians. We will still be able to do that, is my understanding. Is that not correct?
It's truth in advertising.
Truth in advertising, that's all, and it's an affirmative labeling, right?
Any other questions or comments?
Madam Speaker?
Yes.
Going back to Councilor Soap's statement, I think there may be a couple people in the audience that wanted to say something.
When the council's finished, Dr. Cobb will do that.
Before we do that, I have a question. Is this going to allow us to put a sign on our gift shop that says all artists in here that are Indian are labeled?
I mean, yeah, that could be part of it.
I'd like to see that, because you're going to set two baskets down, one labeled and one non. People may not recognize it. They're going to look at the one that looks really, really good, and I tend to look at the one that's made by an Indian. And I want to make sure the advertisement is out there that they're going to do that.
Point. Any other questions or comments? Now, Mr. Soap, did you have someone here representing a group or?
No, I just thought that it would be, something that's good for the committee to do at this time, is just to allow public comment. That was one of the things that was brought up, that, we've had plenty of time, but I haven't been a part of any public forum to where people have had the opportunity to address their concerns on a personal basis, other than phone calls or emails or whatnot. But, I thought we'd just at least allow people the time to address the podium at this time before it be voted on, because it is one of the more hotly debated issues that I've been a part of, and it impacts a certain group of people that need to have their voice heard.
Mr. Hoskin?
If we do that, Madam Speaker, is it possible to identify how many are wanting to address it, and then perhaps limit it to the debate to appropriate amount of time?
Yeah, we have 30 minutes remaining before the next groups, the next committee starts. So how many people do we have that are here to speak to this legislation? 1, 2, 3, 4. Okay. We'll allow, as was stated earlier, we'll allow 2 minutes, but if you need more, then we've got 30 minutes. Should they want to. Yeah, well, you want to introduce yourself and...
that wants to go. Supposed to let my elders go. So I thought I'd ask. Okay. Don Salome Mackey, Dawado, Tahlequah, Janela. My name is Donina Squirrel Mackey. I'm from Tahlequah. Actually, I live in Tahlequah, but I'm from Kenwood. I'm the Vice President of the Cherokee Arts and Humanities Council, Inc. And Wado for the opportunity to allow me to speak today.
Last year, some like-minded individuals and I formed the Cherokee Arts and Humanities Council because we too have concerns about the current condition of Cherokee society, our society. I'd like to speak on this act. This act is called Truth in Advertising, but it is more of a truth in identification, a federal truth that the Cherokee Nation has adopted, but it is not necessarily a cultural truth. Art, by its very nature, should fit firmly within the cultural category. The policies and infrastructures of governmental agencies are built upon the intricate legal distinctions. There is a federal law in place to protect federally recognized Indian artists. If this legislation passes, the Cherokee Nation as a government entity will create redundant legislation to reiterate a federal law that is rarely invoked. This is a matter of policy and procedure, and not legislation. Policy and procedure can handle our needs within the organizations that already exist to work with Cherokee artists. We just need to be more aware of the issues that affect our artists. Artists are not always just those with fine art degrees, but exist at the grassroots level and community level as well. To believe that non-enrolled Indian artists are the problem is wrong. Non-enrolled artists and enrolled artists can both be good at marketing their product, but I'm more concerned about those that aren't, that make really great things out there and have the problem coming in and selling their wares. I want to know, what are we going to do to help those folks? And this legislation doesn't really address that issue. What I have found about art, and I'm not an artist, I'm an art lover, I'm an art collector, I depend on other people for art, I can't do it. But I have found that, there are enrolled Cherokees that do art well. There are enrolled Cherokees that do art that's not so good. There are Cherokees doing art that has nothing to do with Cherokee. There are non-enrolled Native people or your average citizen doing Cherokee work really well. Non-enrolled doing Cherokee work not so well. And so I wonder, of these categories, what is the most damaging to us? I think putting work out there that gives false ideas about who we are as Indian people can be dangerous. I would like to ask that store managers, and we have store managers here today, they need support and they need to be able to deal with the artists as the artists to serve their needs quickly and not wait for periods of time to pay artists, and be able to work with them year-round and not just during seasonal times. They need to be able to evaluate an artist on quality, imagery, and is this a rare item? Is this a living treasure that's coming in? Is this a ceremonial item? We sell from time to time turtle shell shackles and turtle rattles that are still used in ceremonial life. And this is our medicine. And are we supposed to sell it? And are we supposed to sell it at 100% markup? So these are issues that I am concerned about. There are enough artists to stock our stores. We need to value our artists, to let them know we appreciate the work they do in keeping our culture alive. Basketry, you mentioned basketry. There's a difference in, we still have some elder women that I'm aware of, very few, that go out and get the material themselves. It has to be found in a place where there were no cattle so that material's not damaged. They pick that butt brush, they clean it, they gather dyes. Sometimes they use walnut, bloodroot, and pokeberry. Not all of those are in season at the same time. There's very little on the outside that they bring in to make that basket. It's done from their hands, their creation. And it's a long process. It could be a year-long process. And so when we value something, we need to look at what's put into it rather than, to me it's the work, and it's the what's representing who we are as people. And sometimes it comes very well from a registered person, a federal person, or not. And that's what we need to put that in the hands of our people here that run these stores and deal with these artists.
Ma'am, can I interrupt you for a moment? That's 5 minutes. Did you have questions of the council, or does council have questions of, I'm sorry, what was your name again?
Donina Mackey.
Sonia?
Donina Squirrel Mackey.
Kara, did you have a question? I saw you making some notes there.
I didn't have any questions, but I don't think that there's a couple of things. This act, there's several of the concerns that you have are not meant to be addressed in this act at all. It should be something separate, and I don't know that it would be legislated. It would be something that maybe your group or other groups, would do. Marketing is addressed somewhat in it, in that we give them a free outlet through the tarot list. The little grandmas and those folks, that it would be a way that they could opt in to an Excel spreadsheet that would be available to folks. So the JOM groups and outside groups like corporations, if they wanted to hire them to do stuff, they could, and it would be a free marketing outlet.
Yeah, it sounds very corporate.
Well, I mean, but if they want access to expand their business and not have to aggressively do it, they just fill out once, it would be free to them, which is more than Eastern Band does, because Eastern Band does something similar, but they actually charge. So that was the only way as a body, without intervening in the cultural aspects and the art, that we could do. Our concern here with this act is the truth in advertising. As we develop cultural tourism to help folks in the more rural settings, they should get it. If they're Cherokee and they're making those kind of baskets, they should get national market value and not, some of the other stuff. Well, if we have non-Indians in our community claiming to be Indians and all those, then...
Excuse me for interrupting, but can you wind it up in 1 minute?
And so I think that you brought up a lot of excellent points, but they're not in part of this act. And they're not. So I'm concerned that the one thing is the federal law is different in that it includes state-recognized tribes. Well, we have a problem in Cherokee where we know our history is very clear. Kentucky Cherokees and some of these others don't exist. They are white folks that took our land and now claiming to be Indian, most of them, or a lot of them. And so that's different. The federal law includes state-recognized tribes, and that's not true. They're not included in this, and it's very different. It's not redundant.
I would like to have 1 more minute.
Okay, 1 more minute, because we've got 2 more items I forgot about, so take 1 minute so that the other people have time to speak.
She talked about Kentucky Cherokees. I believe Merv Jacob was there. I think he's our most famous wannabe, and I don't like that term. I don't think it's a good term. But one time, Marie Proctor, who does these traditional baskets, came to town, couldn't sell her stuff anywhere, and I'm not sure why. And because these ladies do have guidelines they have to go by, and so a few days later I went to visit Merv, and he said Marie Proctor came in and I bought her baskets. She needed some money. And he said, I'm just going to resell them for what I gave for them. And I know what she charges for baskets, and I knew that's what he was selling them for. And I want to just say, that's Cherokee. It's not legislation. It's not Constitution. It's not DAWs. It's not all those things. That's Cherokee, because he has been here with us for a while now, and he understands the behavior, the culture. I understand that there are DAWs, there are things that control us. But if we're going to insert ourselves as sovereign people, are we going to follow an outside government guideline? And I just don't feel like that this legislation and that fits with us as Cherokee people. I don't think art can be legislated. I just don't feel like it. I feel like it really is a policy and procedure issue. Widow.
Thank you for coming. And who is next? Yeah, you want to come forward?
Linda Taylor, and I manage the gift shops. I just need some clarification as far as the writings and music. I know this has been changed several times and quite a bit taken out of it. Where originally tarot was in there, is that on a voluntary basis now? Now the writings and music, in all of the books we have, are we going to have a committee that goes through those books and tells us what's acceptable to carry?
Ms. Count Watts?
The only thing that, I mean, that's a different issue. The only issue that we have is, for this act, is whether or not if the person writing the book, for example, claims to be Cherokee, for example,
Right.
then they better be a Cherokee citizen, either of Eastern Band, Cherokee, UKB, or Cherokee Nation.
Which I have no way to verify that, so there would have to be a committee set up. I know I do have people that come in and screen my books from time to time looking for those kind of things. But
I'm sure we can provide assistance. You know, some.
I would like
some
that
way.
because I'm not particularly, I don't, you know, as far as like the products in the gift shop, truth in advertising, our baskets have labels on them. They have the tribe on them. We might have one non-Indian we buy from, and those are pine needle baskets that none of our tribal members make. So, you know, I just want clarification on this.
It's the same as what Mr. Baker shared, is that it has to be, if you're saying it is an Indian art, then it needs to be a federally recognized tribal citizen making it, writing it, performing it.
Right. So we really need to be, as far as myself and the people that help me at the gift shop, we need to be very diligent, particularly on our writings and the music. We need somebody to guide us, I guess, because you know how many books are out there and people that write history on the Cherokees. I just want clarification on that, and if this goes through like it is, then you know, we're going to have some help.
When we met with Gina Olaya, she assured us that that would be something CNE could comply with, and I'm sure that...
Well, was I in that meeting?
Yeah, we were over at the restaurant.
Eating?
Yeah.
Okay. Well, but there's been a lot of changes since then also.
Same thing. I mean, it's the same intent, truth in advertising.
It's the same intent, but there has been a lot cut out as far as like the tarot, where it originally said tarot shall have the duty.
Yes, now it's optional.
Right. So that's what I want to see. Okay, I just want to make sure that, you know, we're just not left out there and then somebody's going to come and say, oh, you're breaking the law on this book
I'm sure
here.
but by the meetings we've had with you so far, you know that we're here to try to help. So.
Yes. Thank you.
And who's next? Thank you, Ms. Taylor. Who's next?
You're in.
Come forward. How are you, Richard?
I'm good, thank you. Thanks for allowing me time to speak. I'm Richard Allen, policy analyst with Cherokee Nation. I deal with, for want of a better term, wannabes every day. Those claiming to be Cherokee, those trying to validate themselves as Cherokee, those who have become aware of a Cherokee heritage possibly that may not be in any other means validated. I'd like to respond to some of the things that were said. Had Mr. Jacob bought those baskets, sold them at a higher price, and gave the lady the income for that, then I would call that Cherokee. Otherwise, he's just validating himself by bringing on board Cherokee items. We see that all the time. About 3 years ago, I guess, 4 years ago, an installation was done in Chattanooga, Tennessee, using Cherokee artists. That artwork came about as a result of one of the consultations I had in Chattanooga with the city with regard to the impact that was already occurring to Ross's Landing. Ross's Landing had no real integrity. It had been lost a long time ago. But what was being posed there by, for want of a better term, the wannabes in that city was a huge display. They wanted a statue of dragging canoe placed somewhere in the city. They wanted cutouts of Cherokees held in prison in perpetuity. And the people who represented the Eastern Band and myself representing the Cherokee Nation said, no, that is not the way to represent Cherokee people. And out of that came, the result of that, the outcome was a request for qualifications, or what we normally call a request for proposals for artwork. And in that, we required that only citizens of the Cherokee Nation, the Eastern Band of Cherokees, the United Kutuwa Band of Cherokees, and the Creek Nation be eligible to submit those requests. And so they did. They received 12 requests from people who were nationally recognized, internationally recognized, who happened to latch on to a Cherokee and bring them in. A good example is somebody brought in Freeman Owl. All he did was tell a story. But the artist had a proposal they wanted to submit. And that artwork was valued at, the contract for that was well over $250,000 when it was over. And as a result, the Cherokee artists who call themselves the Gadoogie artists won that particular contract. That is good work. That is good art. It is in the city of Chattanooga. We deal with this every day. The legislation, I think, is to protect. Okay, maybe it hasn't been enforced so much by the federal government, but it's beginning to do that now. The recent case with the Lewis and Clark commemorative coin, there were 2,000 bags made for that coin. Those are being recalled. The federal government found that the people who made it, the quote, Shawnee Nation United Remnant Band of Ohio, is not an Indian group. It's not state recognized. It's not federally recognized. So they're having to recall that artwork. The Kauai Indian Nation, who's been selling membership to immigrants, illegal immigrants in Kansas and elsewhere, is a good example of what can happen. We are just trying to protect who we are as Cherokee people with this legislation, and I think it's important that we do so. I get tired of dealing with wannabes, and I do deal with it every day. People who want to be put in touch with shaman, people who want to be recognized as Cherokee, they all have stories. They all have a princess grandmother, and you all have heard those stories. We know who we are as Cherokee people. We know who the United Kutuwa Band is. We know who the Eastern Band is. Those are the only Cherokees that we should recognize. There are no Cherokees in Tennessee. One group in Tennessee, I have to tell you this story, took the list of intruders that we had submitted to the federal government in the 1830s, I believe. They took that list and said these were their Cherokee ancestors. They're so ignorant they didn't realize that these people that they were referring to were intruders into Cherokee Nation. So we get that kind of stuff all the time. And we get a lot of ignorant people who don't know what it is to be Cherokee. They didn't grow up Cherokee. They don't have that Cherokee blood heritage. That heritage is important to us. We've got to protect it. And with our artists, whoever it may be, whether we're selling it or not, there are ways to identify this is Indian, this is not. And we've got books like that telling you how to do a sweat lodge ceremony, things of that nature.
Richard, I'm sorry to interrupt. I could listen to you all day, but we have another speaker.
Okay, that's fine, but I did want you to hear that part of it.
Anybody have any questions or comments for Richard? Thanks for coming. And there was one more person who wanted to speak. Good afternoon.
Yeah. My name is Sharon Earla, and I represent Cherokee Artists Association. And I just would like to say that our association members has had a meeting to discuss this legislation and have voiced some concerns about it. However, since the date of our discussion, it appears that the wisdom has prevailed, and several of these related items have been already modified or stricken entirely from the Act in its original form. But due to prior obligations and schedules of our members, we've only had an opportunity to review this latest revision and not discuss it at any length. So we would like to request some additional time to go over especially these recent changes. So we'd just like to, we'd like to get a little bit of additional time. But I would like to let you know that our association does support the idea of proper identification and labeling. So that's really all I have to say on it right now.
Any questions of council, or does council have any questions or comments for Sharon? No, thank you for coming. Now we'll bring to a vote this legislation as amended. We removed item F of Section 5 And wasn't there another, you included something too, wasn't it? Kara,
That was-
contemporary
Yes,
into, what section is that?
it's the definition of art, section 4A.
4A? And you want to read that as amended?
So, section 4A would then read the second sentence. Art also includes all those things, and then after other performing arts, you would add contemporary art or techniques and printed materials.
Contemporary art is what you're including?
Yes.
Yes.
Madam Chairman.
Yes.
I
Mr. Baker?
move to table this at this time for 30 days to give the Artists Association time to go over it thoroughly and come back one more time. Put that in form of motion.
Moved and seconded. All in favor of tabling for 30 days signify by saying aye.
Aye.
All opposed, same sign.
No.
Roll call.
Joe Crittenden,
Yes.
Jody Fishinghawk. Yes. Meredith Fraley,
Yes.
Janelle Fulbright. Yes. Don Garvin,
No.
Chuck Hoskin Jr.,
Yes.
Tina Glory Jordan,
Yes.
Curtis Snell,
No.
Chris Soap,
Yes.
David Thornton,
Yes.
Kara Cowan Watts,
No.
Bill England,
No.
Bill John Baker,
Yes.
Jack Baker,
No.
Harley Buzzard,
No.
Julia Coates,
No.
Brad Cobb.
No.
We have 8 no, 9 yes.
9 yes to table, 8 to not table. So we table for 30 days.
Madam Chair,
Yes.
wouldn't it not be tabled till the next rules meeting, which is less than 30 days, because
I'm
it's
in
December
till
20th?
next month is what I really want.
Okay, because
Okay.
So if it's
Next
29,
rules.
it doesn't matter.
next rule is December
So
20th.
tabling until next rules meeting.
Yeah, that's what I meant.
Okay, item 4 is a resolution requesting the Claremore Indian Hospital and the parcel of land there surrounding that as Indian country. Ms. Calwad?
Move to approve.
Second.
Moved and seconded. Any discussion? Any discussion? All in favor, signify by saying aye. Aye. All opposed, same sign. Okay, item 5, Todd, do we have a resolution or something here for this?
Yeah, we'll pass it.
There's no resolution.
Madam Chairman, there's no resolution. This matter was brought up this afternoon. However, with the time constraints, if the committee approves the appointment of Ms. Barger Johnson and Mr. Ketcher to be the council nominees, this would be sent to full council, in which there will be a resolution to be signed that will appoint those to the compensation committee.
I move to approve items 5 and 6 for full council.
Second motion.
Moved and seconded. Discussion. Ms. Barger Johnson did serve on the former compensation commission. Very, very qualified lady. We all know Mr. Ketcher, so in favor signify by saying aye.
Aye.
All opposed, same sign. The next meeting will be December 20th at 1 o'clock. And any other announcements? Oh,
Yes.
Mr. Baker.
I would like to thank our secretary for sending out our packets and booklet form, and we appreciate it very much.
They were tabbed.
I entertain a motion to adjourn.
So moved.
All in favor, aye. All opposed.